Hi, my name is Nguyen, and I'm currently an associate at Midland Partners law firm, which specializes in legal consultation for enterprises in Vietnam. And recently, I also have the privilege of working closely with my two senior tutors at Foreign Trade University, Ms. Kim and Ms. Nguyen, who are both PhD holders in terms of economic law. And together, we have been working and engaged in this academic and policy-oriented project, and now had the honor of publishing this research paper in the Journal of East Asia in International Law. You can find our paper with the title of Legal Foundations of Vietnam's Emission Trading System, a Path Toward Climate Commitment. Our paper therefore will focus mainly on the legal framework for Vietnam's emerging emission trading system, or the ETAS, which is a key component of the country's strategy of meeting its net zero commitment by 2050. And legally, the foundation of Vietnam ETAS primarily lied in the Environmental Protection Law of 2020 and the Decree No. 6, 2022 of the government. The framework will adopt a cap-and-trade model, where the government shall set an upper cap on the green gas emissions and then, issue allowances to be traded among regulated entities as a special commodity in the market. And the system is designed for phased implementation, with a pilot covering from 2025 to 2026 and a broader application plan by 2028. 6 priority sectors are now covered under the ETAS, but we suppose that in this pilot phase, the ETAS may only start with key sectors like the power, cement, or steel, those that are mainly affected by the CBAM mechanism, or the carbon border adjustment mechanism by the EU. Moreover, legal provisions also anticipate future mechanisms such as carbon banking, carbon borrowing, or the carbon credit offsetting, or eventual outsourcing of carbon allowances, replacing free allocation like at the moment. However, the Vietnam regulations still faces many challenges. For example, the carbon allowances and credits are now recognized as tradable rights. However, their legal classification under the Civil Code of Vietnam are still unresolved. Some more examples, like the regulatory instruments such as the National Registry or the Carbon Exchange Platform, are still under development, causing huge barriers for market participations to join the race. And as a result, we now accuse that for the ETAS to succeed, the Vietnam must develop a standalone legal instrument like a new decree, or amending the existing regulations like the Civil Code to clearly define the legal nature of carbon access, to clarify the rights and obligations of market participants, and also to ensure the compatibility with the international standards. And we believe that this legal improvement will be critical not only for the environmental outcomes, but also to ensure a long-term policy credibility. And thank you for listening, and we hope you will enjoy our paper.